Hello, hi, and welcome. So, this session we are going to discuss a very important topic in your examination point of view. So, the topic is what are the provisions related to dealing of securities in stock exchanges? You already know that for raising the capital of a company, there is a need for issuing a prospectus. So while issuing the prospectus itself, the company should have to ensure compliance to certain other aspects. One such aspect is that the shares which are proposed to be issued to the public must be dealt with in stock exchanges. So, to deal with the securities which are going to be listed in the stock exchanges, there is a certain procedure complied by a company. So the first step in that aspect is filing of an application with the recognized stock exchanges. So in accordance to section 40 subsection 1, whenever a company making a public offer shall have to make an application with one or more recognized stock exchanges, and it should obtain permission for the securities to be dealt with in such stock exchanges. So the first point says that filing of an application with the recognized stock exchanges is mandatory, and it can be at least one or more stock exchanges. It has to make an application and obtain the permission for securities to be dealt within such stock exchanges. And the second point says that prospectus to state name of stock exchange. So in the prospectus, what is to be mentioned? The name of stock exchange or exchanges where the shares of the company will be dealt should be mentioned in the prospectus. So once a company makes an application and obtains the permission from the stock exchange or exchanges to deal with the securities of that particular company, the same has to be furnished in the prospectus stating that these are the stock exchanges where the securities are to be dealt with. And the third point says that the company should, before going for a public issue, has to maintain a separate bank account in the scheduled bank in order to deal with the monies collected by issue of securities to the general public. So all money received on application from the public for subscription to the securities shall be kept in a separate bank account in a scheduled bank, and the same money shall not be utilized for any other purpose except two things. One is for adjustment of allotment money of securities, where securities have been permitted to be dealt with in stock exchanges as specified in the prospectus. So one exception for dealing the money in the scheduled bank is for adjustment against allotment of securities, and the second is for the repayment of monies within the time specified, where the company is not able to allot any securities due to one or the other reason. So students, the third point says that the money received on application from the public for subscription to the securities shall be maintained in a separate scheduled bank account, and it shall not be utilized for any other purpose except two things. The first one is for adjustment against allotment of securities, And the second one is for a repayment of monies within the time specified, where the company is for any other reason unable to allot securities. And the fourth point that are to be dealt with under this topic is conditions purporting to waive compliance shall be void. If there is any condition which require or bind any applicant for securities to waive compliance with any of the requirements of this section shall be void. So which mean to say that in the prospectus there should not be any condition which will give an opportunity to the company to waive any of the above said compliances will be considered as a void. Say for example, not having a bank account with a scheduled bank. Instead of that, if the company wants to have a bank account with some private bank, and if it is mentioned in the prospectus and it binds the applicants to subscribe for the securities with the condition, such a condition will be void. So that is what it is being told in the point number 4. And the fifth point says, in case of any default of the above said 4 conditions, above said 4 clauses or 4 points, while dealing with the securities in any stock exchanges, all such defaults would lead to a certain liability against the company and the officer of the company. Both of them are liable. But if it is a company, the liability, there is a fine against the company. And when it comes to the officer of the company who is in default, will be liable with the imprisonment or fine or both. So the penalty is given very clearly. If it is a company, fine varying from 5 lakh rupees to 50 lakh rupees. And if an officer is in default with any of the provisions of any of the provisions under this section while dealing with the securities in any recognized stock exchanges, the officer is punishable with imprisonment up to 1 year or with a fine varying from 50,000 rupees to 3 lakh rupees or both. So this is the liability in case of any default with regard to any of these provisions. One is filing an application, and second is prospectus should name the stock exchanges where the shares are to be dealt, and third is the maintaining of a separate scheduled bank account for the monies to deposit that whatever is being received as an application money for subscription to the securities, and the same money should not be used for any other purpose except two. One is for adjustment against allotment of securities, and other is that for repayment of monies if securities are not allotted. And any of the conditions waiving in the prospectus to bind a subscriber to apply for the shares is considered to be void. So in all such defaults will attract a liability both to the company and the officer in default. And for a company, the liability is minimum 5 lakh to 50 lakh rupees, and for an officer, imprisonment up to 1 year or fine of rupees 50,000 rupees to 3 lakh rupees or with both. And the sixth and the last point, while dealing with the securities in the stock exchanges by a company before going to issue any public offer, is a payment of commission to the underwriters. Students, you have to understand certain companies when they go for initial public offer or further public offer or offer for sale of securities of a company, in all such situations they may go for underwriting the issue of securities with any person. The person may be a company or a firm or something else. So in all such situations, the company will have to pay some commission to such a person in connection with the subscription to its securities. So the payment of commission may be whether absolute or conditional, subject to the conditions as given in Rule 13 of the Companies Rules 2014. So students, here you have to make a note: the payment of commission to the underwriters while dealing with registering the securities with any recognized stock exchanges will itself be a separate question for your examination. So based on this sixth point itself, there can be a likely question for you. If at all such a question is being asked, how the question will come is: what are the conditions specified as per company's rules with reference to payment of underwriters commission? So with reference to payment of underwriters commission, what are the various conditions that are specified in Rule 13 of the Companies Rules 2014? That itself can be a separate question for you in your examination point of view. So the conditions are very simple. There are about six conditions. Very simple, and six conditions are there in the sixth point while dealing with the securities in any recognized stock exchanges before going to issue a prospectus. So the first condition is that the payment of such a commission shall be authorized in the company's articles of association. Students, you know that the articles of association is a governing rules of the company for management of its affairs are being given in the articles of association. So for payment of such a commission, there should be a provision to authorize the company as per its articles of association. And the second point is that the commission may be paid out of the proceeds of the issue or the profit of the company, or both. Say, out of the proceeds of the issue, whatever the company is collected out of that, a part out of that, in absolute or the conditional way, the underwriter's commission can be paid, or sometimes it can pay out of the profits which are being accumulated by the company so far, or the company may make use of either both the proceeds of the issue and the profit of the company to pay underwriters commission. So this is the budget head for payment of commission, and this is the source of money for the company to pay the commission to underwriters when it go for a public issue while dealing with the stock exchanges. And the third point with regard to condition for payment of commission to underwriters is the rate of commission. So if it is absolute, there will be a defined amount will be there. That amount will be paid to the underwriters for subscribing to underwrite the issue of securities to the general public. And following is the rate of commission to be paid to the persons. It is very simple, students. In case of a shares, the commission shall not exceed 5% of the price at which the shares are issued, which mean to say, if the face value, nominal value of the share is rupees 10, the underwriter's commission shall not go beyond 50 paise of that share as a commission. If it is a debenture, it shall not exceed 2.5% of the price at which the debentures are issued. So here it is 5% in case of shares, and it is 2.5% in case of debentures. Or this is the prescribed rate. And if the articles of the company prescribes some other percentage which may be less than the 5% or 2.5%, or more than that, the condition says that whichever is less is applicable. Say for example, if the article says that 4% of the price at which shares are issued will be given as a underwriter's commission, then in such a case the 4% will be the rate of underwriter commission. So the reason is that whichever is less is been mentioned here in the act as a condition. So the next rule number D, which is the fourth rule with regard to payment of commission to underwriters while issuing any shares, is a disclosure of particulars. The particulars of the commission shall be disclosed. The following particulars: the name of the underwriters, the rate and the amount of commission payable to the underwriters, and the number of securities which is to be underwritten or subscribed by the underwriters, absolutely or conditionally. These 3 points should be disclosed in the prospectus without fail with regard to the underwriters. And the fifth condition with regard to the payment of commission to the underwriters while making any issue of securities by a corporate through a prospectus is no commission to be paid. No commission to be paid. There shall not be paid commission to any underwriter or securities which are not offered to the public for subscription, which mean to say the commission should be paid only against the shares offered to the public for subscription. And the last condition here is that a copy of payment of commission to be delivered to the registrar. So whatever the commission is paid to the underwriters in accordance with the disclosure in the prospectus, a copy of the contract for the payment of commission should be delivered to the registrar at the time of delivering the prospectus for registration. So dear students, these are the 6 points which deals with the payment of commission. So a question may likely to come only with regard to the underwriter's commission conditions. What are the conditions specified as per company's rules? Payment of underwriter's commission. If you could able to write all these 6 points, if the question is for 6 marks, you will get 6 marks as it is without getting deducted a single mark. So that is the beauty of the company law paper, where you can give a right and correct answer, then you will get fantastic marks like that of any problematic paper. So the gist of the question here is that, so the question may come as a big question, maybe for 8 marks or 10 marks sometimes, stating the asking that what are the provisions related to dealing with the securities in stock exchanges. In such a case, you have to write all the 6 points, and within the 6 point, that is the payment of commission, you will have another 6 points to write. The total together will be 12 points. So this is about one most important topic in our examinations. And the next important topic is with reference to allotment of securities by company. So students, you know that once the company issues any public offer to the public inviting to subscribe for securities of the company, and if the public makes an applicant, then the company is under an obligation to allot the securities to the subscribers. So with regard to allotment of securities, what the act says, various conditions and the relevant provisions. So what are the various provisions governing allotment of securities by a company is the possible question that can be framed out of this content in our course material. So allotment means the appropriation. What is that? Allotment means the appropriation out of unappropriated capital of the company. So whatever is not appropriated, that will be appropriated by means of allotment. So, till such allotment, the shares do not exist as such. It is on allotment that the shares comes into existence. So, only as and when the shares are allotted to the subscribers, then the allotment takes place, and only after that the capital will come into the picture. And here section 39 subsection 1 says that no allotment of any securities of a company offered to the public for subscription shall be made unless unless the amount stated in the prospectus as the minimum amount has been subscribed and the application money is received by the company either in the form of check or other instrument as specified. So dear students, here allotment will take place only when the minimum amount has been subscribed. This is the point you need to remember. So in the prospectus, the minimum subscription amount will be specified. Only the company once receives the minimum subscribed money as it is mentioned in the prospectus, then only it can allot the securities to the subscribers, and to the subscribers on receipt of the application amount. So application money should be received from the subscribers, and generally the application money as per the act is the 5% of the nominal value of the shares. So once the company receives that 5% money by way of check or other instrument and it is being credited to the concerned scheduled bank account for which a specifically been opened, then only the company can proceed for allotment of capital which is unappropriated. So only when the allotment takes place, then only the capital will arise for the company. So the amount on application, the amount payable on application for security shall not be less than 5%. Shall not be less than 5% of what? 5% of normal amount of security, nominal amount of security. Whatever is the nominal amount that is being designed or the prescribed, out of that 5% should be the minimum application money which is to be paid, or any specified amount or percentage by the SEBI in this behalf. So either 5% or any other percentage or amount as specified by the Securities Exchange Board of India will be the minimum application amount that is to be collected before making any allotment of securities to the subscribers. And the third point says if the stated minimum amount has not been received. So what is the course of action? If minimum amount is not received, minimum amount is not subscribed, and the sum payable on application is not received within a period of 30 days, within a period of 30 days. So as and when a issue is opened and the within a period of 30 days the company has to receive the minimum subscription, and that has to be received within a period of 30 days from the date of issue of prospectus, from the date of issue of the prospectus. So or such other period as may be prescribed by the Securities Exchange Board. So the amount to receive, if not received, what is to be done? It has to be returned. It has to be returned within the prescribed time. So dear students, here the prescribed time is within 30 days from the close of the from the close of the issue of securities. Then the company is under obligation to return the money to the subscribers to the same bank account from where they have remitted the amount against the application money. So the fourth point is that wherever a company having share capital makes any allotment of securities, it shall file a it shall file with the register written of allotment. Written of allotment. So a written of allotment should be filed with the register of companies by the company after allotment, which mean to say whatever unappropriate capital will get appropriated once the allotment of securities takes place to the subscribers to shares. So, in all such cases, it is the duty of the company for making an allotment of share capital. The same is to be filed with the register of companies, that is called a return of allotment. So, that is the prescribed procedure with regard to allotment of securities. So if any of that procedure which is laid in subsection 3 or subsection 4 is violated, then in such a case, such a default shall be liable to a penalty, And as you all aware that the penalty will be both against the company and as well as the officers who are in default will also be liable. The board of directors who are behind that particular issue will also be liable. So here a flow chart is given as a recap of all the points that we have discussed so far. So allotment of securities, what is required? Minimum amount should be subscribed. Otherwise, that is to be returned back. So application money have been paid and received by the company. Only then after allotment of securities will take place. And application money should not be less than 5% or such other percentage as it is prescribed by the SEBI. So these three conditions are to be fulfilled for allotment of securities. Students, you have to understand for allotment of securities, these three conditions are to be fulfilled. What is that? One is the minimum subscription has to be received and the application money has to be received and get credited into the company account. And the third point says that application money shall not be less than 5% of nominal value of shares or such other percentage or amount as specified by the Securities Exchange Board of India. So that is the first laid condition for allotment of any securities. And the second aspect is that the minimum amount not subscribed and application money or if not received, the company is bound to repay that money. So, to whom that money is to be repaid, whoever is paid to the company for application of shares, to all of them that money should be repaid within 30 days. Within 30 days from the date of issue of prospectus, minimum amount if not subscribed. Such other period as may be specified by the SEBI. The amount received shall be returned within 15 days from the closure of issue. Within 15 days from the closure of issue. And dear students, if that money is not returned within the 15 days of the closure of issue, there is a interest for the delay also. Where company makes an allotment of securities, in such a case, the company is under an obligation to file the return of allotment with the register of companies. In case of violation or contravention to any of the above said provisions, company shall pay penalty of ₹1,000 for each day during which such a default continues, or 1 lakh, whichever is less, That is the point you need to remember. So, and dear students, in addition to the above said points, in case of once the securities are issued and subscribed, and this needs to be allotted in tune with the conditions as given below. So if the minimum subscription to be received within 30 days of issue of prospectus In case minimum subscription is not received, if minimum subscription is not received within 30 days of issue of the prospectus, what they have to do is that they have to return the money to the shareholders. They have to return the money to the shareholders within the prescribed time. And it also says that the application money should be more than 5% of the nominal value of the amount. And once the allotment takes place, a return of allotment needs to be filed with the ROC. And these are the important things. If the stated minimum amount is not subscribed, in such a case, the money has to be returned to the shareholders. And if the money is not returned within the prescribed time frame under the Act, the interest is to be paid for the delayed remittance of money back to the investors along with the interest at the rate of 15% per annum. The application money to be refunded shall be credited only to the bank account from which the subscription was remitted. So, whatever the bank account from which the investor has paid money for subscription of shares to the same bank account, the money has to be returned by the company within a period of 30 days from the closure of the issue, as and when the minimum subscription amount is not being received. So, dear students, this point is given under Rule 11 for refund of application money. Refund of application money was given under Rule 11 of the company's rules. So with this, it is one most important topic the student have to very clearly understood in your examination point of view. The question again is likely to be asked, what are the various provisions governing allotment of securities? Very simple, and you need to understand what is meant by allotment is, and what are the various provisions with regard to the application money, minimum subscription, and what is the time frame for the filing of return of allotment, and what are the prescribed penalty provisions if the default happens, and apart from that, if the minimum subscription amount is with regard to that, what are the conditions mentioned, that is 5% of the nominal value and the submission of written of allotment. And the rule 11 is the final point, which talks about refund of application money if minimum subscription amount is not received, and if it is not received within a period of 15 days from the closure of issue, so the company is under obligation to pay that along with the interest at the rate of 15% per annum, and that amount also should be credited back to the same bank account from which the subscription was remitted. So this is the point, dear students, and I advise you to be thorough with regard to the two topics that are being discussed in this session, which is very important in the third chapter of company and other laws of your paper 2 in CA course. And I thank you very much, and best wishes to you all as always.